on financial service and general government will come to order. This hearing is titled Oversight of the U.S. Federal Trade Commission. Members will have 5 legislative days with which to revise and extend their remarks and insert extraneous material into the record. I now recognize myself for an opening statement. I'd like to thank Chairman Ferguson for being here today and his leadership over the last several months. The Federal Trade Commission plays an important role in promoting marketplace competition and protecting consumers. Ensuring robust competition is vital to fostering economic growth while also lowering costs for all Americans. Over the last several years, under previous leadership, the FTC routinely strayed from its core mission and stretched the limits of its statutory authorities. I'm encouraged by the Commission's renewed focus and direction under your leadership. Advances in technology and the emergence of artificial intelligence have presented new opportunities and challenges for businesses and consumers alike. American innovators are at the forefront of these major technological advances. While regulators have a responsibility to maintain common sense guardrails, they should do so in a way that does not stifle innovation and force good-paying jobs overseas. The FTC's spending level for fiscal year 2025 was held flat from FY 2024 at $425.7 million. Despite that flat funding, for the last 2 fiscal years, the Commission faces rising costs for expert witnesses, infrastructure, and technology. Furthermore, the recent passage of the Take It Down Act will require the FTC to deploy additional resources to crack down on the publication of non-consensual intimate images, including those generated by AI. I look forward to hearing more about the Commission's implementation of this important piece of legislation and the additional resources that will be required. Chairman Ferguson, you have described the Federal Trade Commission's role as a cop on the beat. Like police officers, the Commission has a responsibility to enforce the law fairly, without bias or prejudice. The American people deserve an FTC that sticks to its core mission of promoting competition and preventing fraud in the marketplace. Providing regulatory certainty and predictability to the private sector will spur an economic growth and benefit all Americans through affordable prices. I look forward to hearing from Chairman Ferguson about his vision for the Commission and the resources that will be required to execute on the Federal Trade Commission's mission. I now recognize the ranking member, Mr. Hoyer, for his opening statement.
Thank the Chairman very much. Welcome, Chairman Ferguson, to the committee. I want to thank you for the work that you have done and you are doing. You had a very extensive statement, footnoted more than any other statement I think I've read for an opening statement. I thought I was reading a law brief. But having said that, it was very comprehensive. But one of the things I noticed in it, and I say this at the outset, well, I'm going to ask questions later. I'm going to be going in and out. It has nothing to do with your testimony. It has to do with, we have 2 hearings going on at the same time. One of my top priorities, Mr. Chairman, as you know, throughout my time in Congress, has been making our workers, our businesses, and our entire economy more competitive. That's why I, as Majority Leader, started the agenda that I called Make It in America, which obviously is a double entendre. People came to America to make it, to succeed. But also, the way we're going to succeed better is to make it, whatever it may be, in America. We're moving towards that effort. But as you point out in your statement, it can be a self-defeating effort the larger one enterprise gets and other enterprises are left by the wayside. Many of the historic bills we passed in the 117th Congress, including the CHIPS and Science Act, the Bipartisan Infrastructure Law, and the Inflation Reduction Act, were designed to promote competition and to grow manufacturing and our science research in America. That's the objective we ought to all share. If you support innovation, if you support growth, if you support development, then you have to support competition. I tell my Democrats, if you want to be pro-worker, you need to be pro-employer. Both need to be in equilibrium, both have a role to play, and both need a referee. You talked about cop on the beat, referee. If you recognize the importance of the free market as I do, then you have to recognize how crucial it is to keep it free and keep it a market. The FTC is essential to that mission to promote fair competition and protect American consumers. It breaks up monopolies that inflate the price of everything from groceries to gas to health care. It protects Americans from scam calls, fraud, and unfair business practices. It stands up for Americans' privacy rights, going after businesses that misuse or fail to secure their personal data. One thing I may just, it ticks me when I get advertisements that I don't ask for on this device, which I own. I don't know whether there's a solution to that, because obviously they got to pay for the product they give me, in quotes. But that's a particular concern I have you may pay attention to. The FTC needs to maintain public trust and credibility to do this vital, nonpartisan work. Now, I mentioned nonpartisan work, but I was starting to say, let me say, I noticed at least 3 times in the opening sort of synopsis of your statement that you use the term the Trump-Vance FTC. I was caught by that because I don't see that very often in statements that are made. Actually, it's America's FTC. Now, you're appointed, you're a Republican, I'm a Democrat, so we have different points of view. But we need to make sure that the agenda of the administration really needs to be, in this case, from your perspective, the agenda of what the FTC is intended to do. Now, we may have differences on that, but I would urge you to do it in as nonpartisan a way, and very frankly, I urge your predecessor to do the same thing. There would be different views as to whether that was accomplished. The FTC needs to maintain public trust and credibility, as I said, and that will help, I think. That's why the agency has always been independent. I'm deeply concerned by this administration's efforts, frankly, to undermine not only the independence that naming it the Trump-Vance FTC would imply, but it also seems to me creeping into almost everything we do, where so-called non-loyalists are being fired. They need to be loyal to the country and to the oath that we all take to the Constitution and the laws thereof, not to any individual or group of individuals. In March, Donald Trump violated 90 years of Supreme Court precedent when he fired 2 Democratic FTC commissioners without any legal cause, which under the law is required. Those 2 commissioners are challenging that action in court. I hope they win. And if it's anything like the dozens of other cases we've seen in the past 4 months, I believe the courts will likely rule against the administration. One more minute. Nevertheless, the Trump's attempt to politicize the FTC ought to concern us all. So should the reports that Elon Musk and his Doge agents may be able to access sensitive financial data the FTC compiles on American businesses, including Musk's competitors. That is the opposite of the FTC's purpose, and we must not let it happen. Democrats and Republicans need to come together to protect this vital institution and ensure that it has the resources it needs to keep serving the American people. I thank FTC's Chair Ferguson for joining us today, and I hope that he can address some of these concerns and speak to the importance of this funding. The American people are counting on the FTC, and the FTC is counting on this committee. Thank you very much, Mr. Chairman.
Thank you, Mr. Hoyer. Today, we welcome the testimony of the Honorable Andrew Ferguson, Chairman of the Federal Trade Commission. Chairman Ferguson, without objection, your full written testimony will be entered into the record. With that in mind, we ask you to please summarize your opening statement in 5 minutes.
Thank you, Mr. Chairman. Ranking Member Hoyer, members of the subcommittee, I'm Andrew Ferguson, Chairman of the Federal Trade Commission, and I'm pleased to appear before you today to testify about the FTC, its competition and consumer protection priorities, and how we are restoring the agency's financial health and public credibility. I'm also pleased to be joined by our newest commissioner, Mr. Mark Metter. I was profoundly honored when President Donald J. Trump appointed me to lead the agency in January. President Trump's resounding victory in the 2024 election has given him a broad mandate to restore our economy. Restoring our economy requires a dynamic business environment characterized by increasing innovation, wages, productivity, and growth. The fruits of such an economy must be enjoyed by all Americans, particularly the backbone of our economy, our workers. Vigorous and effective consumer protection and competition law enforcement is key to facilitating a dynamic pro-worker economy. And I'm honored to be the chairman of the FTC under President Trump and to help drive this pro-growth, pro-worker agenda. I am also honored to run an agency that is filled with lawyers, economists, investigators, and professional staff who are tirelessly dedicated to the rule of law, to promoting competition, and to protecting consumers. They are the lifeblood of the FTC, and we owe our success to them. We also confront challenges. Poor management decisions made by the previous administration have spread our resources thin. Thankfully, the measures we have taken to restore fiscal health to the FTC align with the President's directives to ensure that the agency is operating as efficiently and effectively as possible in the fulfillment of its mission to protect American people from monopolies and frauds. I resolutely believe in the mission of the FTC. No economic system in history has promoted the common good more than the American free enterprise system. No economic system has contributed more to human flourishing. But our free enterprise system promotes the common good of all Americans only if we protect it from anti-competitive business practices, anti-competitive consolidation, and fraud. Without vigorous enforcement of our competition and consumer protection laws, our free enterprise system would benefit only the wealthy and the corrupt. For that reason, the Trump-Vance FTC has gone back to the agency's roots. Vigorous enforcement of the law is our focus. Congress established the FTC to be a cop on the beat for our markets, not to make the rules. We enforce the laws that the people, through their representatives in Congress, have decided best promote competition and fairness. We investigate wrongdoing, and if we believe violations of the law are taking place, we bring lawsuits. If we don't, we get out of the way and let markets promote innovation and growth. We seek to protect competition and combat fraud through vigilant, fair, and thorough investigations and litigation where necessary. The FTC is here to defend our free enterprise system and make it work for everyone. We want to protect Americans when they shop for groceries, when they go to the hospital, and when they speak online. My written testimony discusses in more detail the FTC's important work to protect U.S. consumers and competition, as well as a brief overview of the FTC's budget, resources, and cost-saving endeavors. Today, I will briefly highlight some of the agency's major recent activities and initiatives. We are focused on protecting Americans in the markets that affect them the most. That is why we have focused substantial resources on protecting Americans online. We have ongoing competition litigation against major big tech platforms under both the consumer protection and competition laws. We focused on healthcare markets. The first major competition action undertaken by the Trump-Vance FTC was to enjoin a merger of medical device manufacturers that the Commission alleges would have increased the prices of medical devices used by millions of Americans. I'm deeply concerned by the increasing prices across all of our healthcare markets. The FTC will do everything that it can to ensure that prices in healthcare markets are the product of vigorous competition and that our healthcare markets are free of deception and unfairness. We're also going beyond our law enforcement efforts in the healthcare space by using our Section 6B authority to examine the operations of the nation's pharmacy benefits managers, an industry that manages nearly 95% of all prescriptions filled in the United States. As part of that probe, the FTC issued interim reports in July 2024 and January 2025 on PBM markups of specialty generic drugs. There's still much work to be done on this report, and I have made completing this report quickly and thoroughly one of the FTC's highest priorities. I look forward to presenting it to Congress when it is completed. We continue to focus on protecting vulnerable Americans from scams and frauds. The FTC has a long and proud history of protecting elderly Americans, veterans, and their families from scams and frauds through both education, outreach, and vigorous law enforcement. We're not taking our foot off the gas on that front. Similarly, protecting the vulnerable requires us to protect our children and teens as well. We are implementing an updated rule on the Children's Online Privacy Protection Act, and we'll be hosting a workshop entitled The Attention Economy, How Big Tech Firms Exploit Children and Hurt Families. This event will bring together parents, child safety experts, and leaders from across the federal government to discuss how big tech companies impose addictive design features, erode parental authority, and fail to protect children from exposure to harmful conduct. I look forward to hosting that in less than a month. Again, thank you for the opportunity to testify about the priorities of the FTC. We look forward to continuing to work with this subcommittee and with all of Congress, and I'm happy to answer your questions.
Thank you, Mr. Chairman. I now recognize myself for an initial question. Chairman, under the Biden administration, the FTC took an aggressive and unprecedented approach to enforcement and rulemaking. The commission stretched its statutory authorities and at times took a hostile view towards mergers and acquisitions. Under your leadership, how will the FTC make a different approach going forward? Or will you take a different one? And if yes, how?
Mr. Chairman, I agree with you. I think that the FTC under the previous administration had a bit of an ideological bent against mergers and acquisitions. And my view is that mergers and acquisitions are a very critical part of how the economy grows and how we get innovation. Founders, innovators need access to capital, and people will not invest in new ideas if they can't get their investment back. And mergers and acquisitions is part of how capital flows to innovators, and innovators get their new ideas to us in the marketplace. So M&A is very important. At the same time, protecting Americans from monopolies and from anti-competitive conduct is very important, and that's our job. So I see it as the FTC's mission is to serve as a cop on the beat in the M&A space. If we think that a deal is anti-competitive and we think we can win in court, we're going to go to court. And if we can't, we're going to get out of the way, and we're going to get out of the way quickly. Congress set timelines by which we're supposed to examine M&A activity, and we're going to stick by those timelines. That's on the front end. On the back end, the big change is that we are open to merger remedies at the FTC. My colleague, Gail Slater at the Department of Justice, has said the same thing. The previous administration prohibited remedies as a way to address anti-competitive conduct that didn't require blocking a whole merger. We are open to remedies negotiations with parties. The remedies have to be real, they have to be enforceable, and we have a strong preference for structural remedies over behavioral remedies. But in order to make sure that we are preventing as much anti-competitive conduct as we can, we have to recognize that sometimes we can eliminate anti-competitive features of mergers without blocking the whole thing, and we have to be open to doing that. So on the M&A front, those are the biggest differences between the previous administration and the current one.
Are there any specific enforcement actions or rulemakings that you're looking to reverse?
We tend not to discuss sort of the deliberations on that stuff. I wrote lots of dissents in the previous administration on both rulemakings and enforcement actions. And one of the things that we did when President Trump was sworn in is that we did not accept on faith the lawfulness, reasonableness, or the prudence of any ongoing enforcement matter or investigation, and are conducting our own review top to bottom of everything that we inherited. If we think it's unlawful, if we think it's a poor use of agency resources, if we think it's inconsistent with administration priorities, then we will take steps to eliminate it, to change it, to align it with the law. If we don't, we will continue it. But particularly given that the FTC at the end of the Biden administration raced a huge amount of material out the door, we're conducting a thorough review, and as we find things that we think are either unlawful or inconsistent with administration priorities, we will be changing them.
Complex antitrust cases such as the proposed Kroger-Albertsons merger have required the FTC to spend millions of dollars on expert witnesses in data storage and analytics. How much does the FTC spend on expert witnesses and data analytics each year? And are these growing costs inhibiting the Commission's ability to bring and successfully try antitrust cases?
It is not inhibiting our ability to do it, but it is a serious challenge that we're confronting. So we have a Bureau of Economics at the Commission with some of the country's most talented economists. They do unbelievable work both at the investigative stage and at the litigation stage. We could not do our enforcement work without the Bureau of Economics. But a lot of our cases, not just big tech cases, a lot of our enforcement matters require us to onboard massive amounts of data in order to investigate potential wrongdoing and proceed to litigation where appropriate. And we don't currently have the infrastructure to house, maintain, and access those data in a meaningful way. So we end up paying vendors a lot of money to do that for us. We ran a pilot program at the end of the previous administration on ways to reduce those costs by bringing some of that infrastructure internally. It was very successful. We've been working with other parts of the government to expand that pilot and make it programmatic at the FTC. On the expert front, you're right. Expert witnesses are expensive. Even with our very talented economists in the Bureau of Economics, we often have to hire industry specialist experts from outside the agency. We are imposing budgeting requirements within the agency for the first time, as far as I know, in the agency's history, to make sure that at the outset of litigation, everyone knows what the agency is willing to spend, and we constrain the agency to spend only those resources on litigation. That is going to help save us a lot of money by avoiding the ballooning problem at the end of litigation we've had in the past.
Thank you. The chair now recognizes the gentle lady from Washington, Mrs. Glusenkamp-Perez, for 5 minutes for any questions she may have.
Thank you, Mr. Chair. And thank you, Chair Ferguson, for being here. I appreciate the work you're doing. And you know, before coming to Congress, you might know I ran an auto repair and machine shop and care deeply about a level playing field for small businesses. That is how we build wealth in this country, is a diversity and a level playing field. I think it's a lens of being pro-business and antitrust. And one of the things that I've heard in your testimony is about the expert witness testimony, but I've also had questions about how many people on staff in your department that don't have a college degree, because any of the mechanics I know could point to, you know, a headlight assembly and tell you that there's an issue going on when you can no longer replace a single light bulb and you have to do the entire assembly for $700 where we used to do it for $3. And it's these kinds of things in the lens of, I think, experience of like what is important to people. There are big arguments, and then there are the kind of the things that make or break a household budget. And those things I think are often best informed by having a plurality and a diversity of experience. And so I'm wondering how you are choosing to balance the credentialing of your team.
So I agree with you that having diverse experiences and viewpoints is super important for the FTC to do its work. I think for all government agencies, there is an unfortunate bureaucratic impulse to sort of look only inside the Beltway, interact only with the interests that have inside the Beltway presences, and that generally small and medium-sized businesses will suffer as a result because they are the ones that can't go to the lobby shops in Washington and, you know, inundate Congress and the executive branch with lobbyists. So I certainly agree with you. We're a law enforcement agency, and almost all of our work winds up in court, which means we end up being very lawyer-heavy. We hire from law schools all across the country, even on the commission itself. We have 2 commissioners who graduated from state schools. The previous administration had focused a little heavy on the Ivy Leagues for commissioners. I went to a state school. One of my colleagues went to a state school. We're from all over the country. That lends itself to diversity of experience. And make sure that we don't get tunnel vision from within the Beltway. So I agree with you. It would be very easy to lose focus on the things that matter to Americans on the ground, around the kitchen table, without a diversity of experience, and that is important to me at the FTC.
Yeah, I think, you know, there's been arguments about needing a larger budget to be able to expand the staff, but I think it is about the prioritization of how respect, who deserves a seat at the table, and identifying and prioritizing the experiences. One of the things that I've been looking at, you know, if you, I don't know, my washing machine's from 1997, but a lot of the newer ones, it's like they're playing Tchaikovsky, and they don't last more than, you know, 6 years, and there's very clear design issues and why that's happening. Having more information as a consumer about what the expected what the life expectancy, what the annual maintenance cost, those kinds of ways to get at not building more agency, more bureaucracy, but saying people just deserve the right to have more clarity of information, and would certainly appreciate you know, your support in identifying some planned obsolescence strategies, as well as you know, obfuscation of the durability of a given product might be. Your thoughts on that?
I'd love to work with you on it. Look, the FTC's most important consumer protection mission is preventing deception. And deception under Section 5 is not just straight out lies, it's also omitting things that would be important and material to a consumer before he or she decides to purchase something. And misrepresenting, either intentionally or through omission, the lifespan of a product is potentially a problem. So I'm more than happy to work with you on that, on industries where you think that's a particular problem and require our focus.
You go to McDonald's?
Not often, but sometimes, yes.
Yeah, you know about the issue with the ice cream machines?
I am aware that it is sometimes difficult to get a McFlurry when you want it.
Well, I've appreciated the work that has happened to ensure that people who are buying equipment have the right to fix it. Whether we're talking about a car, an ice cream machine, I think there's some very embedded paternalistic attitudes towards who has the right and the agency and what a material environmentalism and applied environmentalism is in making things that last longer and having clarity for the owners. This tort law goes back to the 1400s. You bought it, you have the right to fix it and maintain it. And I'm hoping that we are seeing a continuation of that and a seriousness of building wealth and economic self-determination in America.
My grandfather had a Ford tractor from the 1950s with which he tinkered up until his death. And I grew up in a farming community, so I understand, particularly to farmers, the importance of being able to repair your equipment without having to go back to the manufacturer. We have an ongoing case against John Deere on this issue. This is also an issue that the states have started to address legislatively. I know that there have been legislation Congress has passed on this front, other legislation considered. Insofar as, preventing someone from repairing violates Section 5, we are prepared to enforce it. We also want to recognize that generally the best approach to problems is to let the people's representatives, both in the state legislatures and in Congress, address it first. And so we don't want to sort of interfere with those efforts. But this issue is important to me. I grew up around this issue. I hear you loud and clear.
Thank you. Yield back. Thank you.
Thank you. Chair now recognizes the distinguished gentleman from Arkansas, Mr. Womack.
Thank you, Mr. Chairman. And, Mr. Chairman, welcome. You're a breath of fresh air. I got to say that. In my words, in my strong opinion, in the last administration was more agenda-driven. And in listening to your testimony this morning, and then in our private conversation, you seem to have the view that your job is like that of an umpire, of a referee, to make sure that you are holding the people and the institutions that are subject to your purview accountable. And again, my words, certainly not yours. And so it's from that standpoint that I think you're on the right course of getting the FTC back to the nuts and bolts, the blocking and tackling, if you will, of what the commission was set up for. I do have a question about budget, though. When we had our conversation, and these are appropriators up here, so it's our job to fund the discretionary side of government, and yours is part of that. We don't have clarity right now. And we need clarity. My assumption is, and I want to be clear that it's just an assumption, that there will be many agencies that will be facing some budget adjustments, some cuts, if you will. And where is the FTC right now with regard to the prospect of having to settle for less and be able to continue to function as a reputable institution within the government?
The agency that I inherited, even at current funding levels, was in a very difficult position. The previous administration had hired employees at levels far beyond what we could afford.
Would you call it bloated?
It was bloated. There was like a 2-year hiring spree that got us to levels that we couldn't sustain. And so it was important to me, coming in as chairman, to sort of make the difficult decisions necessary to restore fiscal health to the agency. And so as the president has, consistent with what he ran on in the 2024 election, oriented the government towards efficiency and being no larger than necessary to carry out its critical missions for the American people, we were already well underway on getting the agency down to a size consistent with what this body had appropriated us. And so we were sort of ready to go on that front, consistent with the president's agenda as well. We've been conducting a thorough review of our contracting. We've already reduced contract spend for this fiscal year by more than $6 million. So we are positioned. We also, as I discussed earlier, are undertaking steps that we are very optimistic about that will, over the course of the next several years, shrink the amount of money we have to pay outside vendors to house our data in some of our big and important investigations and litigations. So we are well on our way to being prepared for whatever budget this committee decides to appropriate for the FTC.
You know, that runs counter to what a lot of agency heads would suggest. They need more money. They need more people. They need more resources. It sounds to me like that you feel like you can, the FTC can do its job.
And that's a testament to the FTC staff. I would put the FTC staff up against the staff of any agency, civilian or federal, in the federal government. And whatever this committee decides to appropriate to the commission, American consumers will be protected by our staff.
Good. In the President's executive order, agency heads, in consultation with the FTC Chair and the U.S. Attorney General, complete a review of all agency regulations under their rulemaking authority and determine which rules create anti-competitive barriers. How do you plan to execute antitrust enforcement in recognition of this particular executive order?
President Trump has put out a bunch of amazing executive orders. I'm not sure I'm as excited about any of them as I am on this one. So when we talk about competition in America, we generally think about monopolies and consolidation and price fixing, which is appropriate. But one of the biggest obstacles to competition, particularly to small and medium-sized businesses, is regulation. And I worked on the Hill. I've seen it in action. I've worked in state government. I've seen it in action. Big businesses will often come into the government and propose regulations that they can comply with quite easily, but that make it very difficult for competitors to rise and challenge them. And the President's executive order tells us, look through the entire code of federal regulations, find regulations that are barriers to entry, that raise rivals' costs, and get them out of there. So we put out an RFI to the public. We said, if you, especially small businesses, if you are aware of regulations that benefit your competitors but make it harder for you to compete, tell us. We will review them. We will make recommendations to the President. We also sent letters to every agency head in the federal government asking them to do the same thing. We will have economists and lawyers at both the Department of Justice and the FTC reviewing these regulations as they are identified to us, and I'm very excited when we eventually send the list to OMB and the President on our recommendations for descoping and deletion.
Yeah, one final comment, because I may not be around if we have a second round of questions, and I want to be able to say this in regard to what you just discussed, and that is I'm sure hopeful that among those things that are considered in this context is Section 1071 of the Dodd-Frank Act, because that is, in Ms. Gluskamp-Perez and I both agree that this small business side of the equation is where the jobs are created and where we need to be creating emphasis as far as the FTC goes. But that's one that is very punitive to our banking community. So I applaud you for the work that you're doing. Keep it up, and we look forward to getting your budget. Thank you.
Thank you, sir. The chair now recognizes the gentleman from Maryland, Mr. Ivey, for 5 minutes of questions.
Thank you, Mr. Chairman. Good morning, Mr. Chairman. I want to thank you for appearing here today. I appreciate your opening comments. I look forward to the report you're going to come back with respect to PBMs. I think it's a very important issue. It's also a very complicated issue, so adding your insight, your agency's insight will be especially helpful. I didn't follow the medical device merger issue in detail, but I was pleased to see that you were open to enjoining a merger. Your opening comments, I think, reflect the fact that you're trying to call the balls and strikes, that you're not trying to be ideological about it. I appreciate that. Continuing the ongoing litigation with big tech, I thought was interesting as well. And I believe the FTC upheld the junk fees, I'll call it, determination, which I think is important. I think it's really one of those things that's tremendously helpful to people across the board. And I do want to join with my colleague from Washington State on the right to repair issue. I think that's one that is very important. Business to business conflicts, that's one thing, but a lot of these scenarios, we have individuals. You talked about a farmer owning a tractor with respect to John Deere, and I know that's ongoing, but that's the kind of scenario I think we really need you to step up and make sure that people are protected so that they can just take care of basic things and run their business or take care of their appliances. McDonald's, I'm not a big McFlurry guy, but if they get a break along the way, that's fine. Click to cancel is another one that I think could really be helpful to a lot of people across the board. I know every time I try and cancel something that frequently one of my kids signed up for, it takes forever to do it. You can sign up in a minute, but getting out of it can take half of a lifetime. So I appreciate anything you can do on that front as well. I do want to say this. With respect to the non-compete issue, I think that, and you opened by talking about the importance of workers and how they're the backbone of the economy, and you want to take a pro-worker approach. The non-compete piece, in my experience when I was practicing, corporation to corporation, no poaching, that kind of stuff, I get it. But there's a lot of times where you have workers, individuals who really don't have negotiating capability with respect to larger corporations. And they want to try and move to do another job or find other types of employment, might have some situation where, beyond their control. And these clauses can really get in the way and hamstring them. And I think I took a look at your dissent on that issue, and I appreciate your views on it. I know a lot of that's procedural, and I don't mean to belittle that, but this is a very important restriction on what regular people can do from an employment standpoint. And I hope that you'll be able to find a way to address that with respect to people who don't have that kind of power. They can't hire the big lobbyists, as you mentioned. And I want to close with this, and I know this is ongoing litigation as well. The termination of Commissioners Slaughter and Bedoya, as you know, caught a lot of people's attention. That would include me. And I know it's still kind of in court, just getting underway. But one of the things that concerned me about that was it didn't appear that there were any grounds for the termination. Now, I note that you issued a statement with respect to it, I think on the day they were terminated. And in the statement you issued, you didn't reference the standard for termination: inefficiency, neglect of duty, or malfeasance in office. And you supported the termination, but not on statutory grounds, not on legal grounds. And I think that's pretty significant, especially given your background. I took a look at your 40-page dissent. Supreme Court clerk. You mentioned being from a state school. You didn't mention it was UVA, which is a little more than a regular state school.
They'll appreciate you saying that.
Well, my brother will too. But my larger point though is, you didn't hit on the law in the statement that you gave. You're a defendant in the case, so I know you'll have a chance to explain your position at length. But I think it's important for us to make sure we understand that independent commissions are supposed to be independent. The president certainly has the authority to make appointments, and as you pointed out, he just did. But there's supposed to be a partisan balance to these, and those terminations upset that balance from a statutory standpoint. So you're in the middle of the case. I want to commend you overall in general for a lot of the positions you've taken, and I look forward to working with you going forward.
Thank you. Chair now recognizes the gentlelady from Iowa, Ms. Hinson, for any questions she may have.
Thank you, Mr. Chairman. Good morning, Mr. Chairman. Thank you so much for coming before our committee to testify and for the great work that you mentioned the incredible staff that you have at the FTC who are keeping American consumers protected. I really appreciate that great work that you're doing. Obviously, holding the bad actors accountable and ensuring that we have a system that doesn't burden our small businesses with excessive regulations remains a priority. I'm really excited to hear that we share that priority. One area that I think is a raging example of that is the pharmacy benefit managers, and I know there's already been discussion about that report this morning, but I think people are getting fed up of seeing people profit off of sick Americans and pushing many of these independent pharmacies in small rural communities like many in my district out of business. And just this week, We actually had a fellow Iowan and president of the American Pharmacists Association, Dr. Randy McDonough. He testified in front of Senate Judiciary Committee this week that in Iowa alone, 200 pharmacies have closed since 2014. A record 31 pharmacies closed in 2024. I mean, those numbers are staggering to me when we think about access to healthcare, access to those life-saving drugs. Really, really important that we find a solution here. The FTC obviously released the interim report in January, revealing that the big three PBMs imposed markups of hundreds of thousands of percentages on numerous specialty generic drugs dispensed at their affiliated pharmacies. So I think we're all trying to wrap our heads around how they've been able to get away with this for this long. Can you talk a little bit about the FTC's plans to not only continue but ultimately complete this study and release that final report?
Absolutely. The commission has gotten huge quantities of data from the PBMs and the GPOs, and we are going through it. I think it's very, in my view, as I said in my concurrence to the first interim report, it was a bit rushed. The work was not the FTC's best. Substantial improvement in the second interim report. My view is that whatever we next produce needs to be a very, very thorough accounting of all the data we have and of all the issues it presents, so that legislators here in Congress and in the states and policymakers throughout the federal government and the state governments have our full understanding of what is going on in these incredibly complicated markets. So we are devoting a ton of resources to getting this done. I want it done as quickly as possible, but I do not want speed to be the enemy of thoroughness. So we're trying to sort of thread the needle to make it as thorough, comprehensive as possible, which includes interacting with PBMs to hear their side of the story, while also making sure that we have a full understanding of what's actually going on in these markets and that you all have it as soon as possible. We have other PBM matters ongoing. This is all public, but we took Caremark to court in the District of Columbia just a couple months ago because they were refusing to comply with some of our orders in a law enforcement investigation, and we won. They were ordered to comply. That was a significant win, not just for our PBM investigation, but for our sort of investigative authority across the board. And we have an ongoing administrative adjudication involving PBMs and insulin. It's difficult for me to talk about that one because I sit as a judge in the course of that proceeding. But this is one of our critical priorities at the FTC, but because healthcare is one of our critical priorities. Everyone participates in healthcare markets, and the prices in healthcare are going up across the board. And the rate at which people have to use the healthcare markets is also going up across the board. And I don't think competition is a panacea to the healthcare cost crisis in this country, but at least the FTC can make sure that everyone is competing within the bounds of the laws that Congress has passed, and that is what we are focused on.
Yeah, this is about a level playing field and protecting consumers at the same time. And I think that I think all of us policymakers are trying to get to a point where we figure out how did we get here in the first place, right? So I don't know if you have any insight in that when you think about the FTC's job to protect consumers, and here we are, decades into this experiment with PBMs, and we've kind of opened Pandora's box, I think. And to your point about trying to be thorough here, time is of the essence because we are seeing states take action. My own home state of Iowa just passed, they just ended their legislative session, I think at like 6:30 this morning, but they just passed Senate File 383. It's one of the most comprehensive state-level PBM reforms in the country. And so, do you have any insight on just overall observations on how we got here and why these steps were not being taken along the way?
So I have my suspicions, but I don't want to get ahead of the report. I sort of want the FTC's work, having analyzed all the data, to be our definitive statement on this. So if you'll permit me, I will let the report, when it is ready for release to Congress, sort of speak on this. I also think it's important. I think state and federal legislative action to address problems that may be posed by PBMs are good. It is always better for the people's representatives to confront the people's problems rather than sort of deferring to the bureaucrats. I think the report will be very helpful as Congress and the state legislatures are trying to figure out what to do. But I think we should all welcome legislative action on this because you all understand the needs of your constituents better than anybody else, including their relationships with the PBMs.
Yes, and the need for lower cost prescription drugs, for sure. Thank you so much, Mr. Chairman, for coming. Appreciate it. I yield back.
Thank you. The chair now recognizes the gentleman from Wisconsin, Mr. Pocan, for 5 minutes.
Thank you, Mr. Chairman. And thank you for being here today. Sorry I missed the opening testimony. you'll see standing here in a second, battling hearings going on. One of the things I think that I really appreciated about former Chair Lena Khan was keeping the FTC independent, and you've mentioned that a number of times. In 2023, you testified to the Senate during your confirmation process that if confirmed as an FTC commissioner, I'll abide by binding Supreme Court precedent. And then you went on to cite Humphrey's Executor versus United States as the precedent that you'd support. As you know, that case upheld the independence of the FTC and specifically limited the president's ability to remove a commissioner. Well, the president has illegally fired 2 of your fellow commissioners, and you went on to publicly support his actions. On March 18th, you said that, quote, President Trump is vested with all of the executive power in our government. I have no doubts about his constitutional authority to remove commissioners. So that's in direct conflict with what you said when you testified before the Senate 2023. So what is accurate, what you said when you were under oath in front of the Senate, or what you said most recently when Donald Trump broke the law?
I'm a defendant in that litigation, but I can tell you what the brief said because the brief is filed in my name.
Yeah, and I'd like to get to 3 subjects during my time, so
Sure.
yeah, thank you.
Sure. Humphrey's Executor is good law. It governs the removal protections for the 1935 FTC. As I'm sure you know as well as I do, the 2025 FTC has orders of magnitude more authority than the 1935 FTC. And what the Supreme Court said in 2020 in SELA law is that the Humphrey's Executor exception does not apply to federal agencies that wield substantial executive
So the
power.
question I had is, which was the accurate statement?
But both of them are accurate. What I said in 2023 is Humphrey's Executor is good law, which is true, as is SELA law, the Supreme Court's definitive 2020
That's fine.
decision.
Thank you, Mr. Chairman. I'd like to enter into the record just the comments from that Senate hearing, just so I can have it entered as well.
Without objection.
Thank you very much. Okay, hopefully we can get 2 more subjects at 2. I'm going to do as fast as I can. I apologize. Last year, the FTC uncovered in the proposed merger between ExxonMobil and Pioneer Natural Resources, Pioneer CEO Scott Sheffield conspired with a foreign entity, OPEC, to raise gas prices for Americans. This price fixing likely cost consumers $2,000 to $4,000. It's been estimated in 2021. After learning of this illegal scheme, the FTC allowed the Exxon Pioneer merger, but prohibited Sheffield from serving on the board or advising the new company in any way, rightfully so. In March, after donating massive amounts to President Trump's election campaign, Mr. Sheffield asked the FTC under your leadership to reopen and alter, modify, or set aside the orders against him. Unfortunately, it seems that it has been reopened at this point, obliging to his request. I know that the commission just wrapped up a public comment period on this, in which I submitted a letter of opposition to that. Could you please let us know how allowing an alleged price fixer who actively colluded with a foreign entity, OPEC, should be put on the board of Exxon, and how that aligns with the FTC's mission of protecting consumers and promoting competition?
I dissented from both of those orders dating back to May 2024. We did not, first of all, we did not proceed on the basis of evidence of price fixing. We accused him of making comments, and that was it, number one. And number two, I don't care if Mr. Sheffield ever serves on that board. I do care that the FTC rigidly follows the law, including Section 7. We had never articulated a Section 7 theory of that kind before. We had never issued an order of that kind before. And my concern remains that it was done in response to dozens of letters from Democratic legislators filed with the committee while we were considering that merger, and that it was politically motivated. I want the FTC to follow the law. And to be clear, I didn't reopen the proceeding. The APA requires that I reopen the proceeding if I'm asked.
Again, I think it would run counter to what both you've said and what Donald Trump has said about lowering costs. So hopefully we won't allow this guy who's colluded with hundreds of messages to a foreign entity to get on a board and rip off consumers ever again. Lastly, in 30 seconds, really quick, an area I don't know if you've ever covered, but I'm checking in Medicare Advantage plans. 4 companies represent something like 75, 80% of the market out there. One of the complaints I think we all get from constituents are people have to get permission to have medical care, and you don't have to do that with Medicare. They get turned down. When those are appealed, only 1% to 3% appeal, the appeal rate gets overturned as 85%. that's clearly, like, they're turning down so many cases that need coverage. Is that something that potentially you guys could look at? Because, again, a few companies seem to be of consolidation in the market, and when that rate is so high, 85%, I'd love to know what your thoughts are on that.
I'm not familiar with the issue, but I would be more than happy to work with you on it. Your staff should reach out to my staff, and we're happy to talk with you about this.
Appreciate that. Thank you very much.
Absolutely. Thank you.
Thank you. The chair now recognizes the gentleman from North Carolina, Mr. Edwards, for any questions he may have.
Thank you, Mr. Chair. Chairman Ferguson, in 2019, the HCA Healthcare, the North Carolina's Mission Health for $1.5 billion. My constituents in Western North Carolina were promised that this acquisition would result in lower patient costs. But after the merger, prices rose higher than the average list prices of the 11 neighboring hospitals, and annual markup prices nearly doubled to an average of 33 percentage points a year. Patients have also experienced a lower quality of health care, with a Centers for Medicare and Medicaid Services report finding that at least 3 patients died and more were endangered at the merged hospital in 2022 and 2023 due to significant wait times, delays, negligence, and lapse of care. Despite this significant decline in quality of care, Mission's patient care profits were almost $100 million in 2022, 3.5 times higher than its profits the year before the acquisition. Chairman Ferguson, in our previous meeting, you expressed similar concerns regarding the increasing prices of healthcare in rural areas as a result of private entity roll-ups and mergers. During your tenure as FTC chairman, what actions can and will you take to protect competition within the healthcare industry?
I enjoyed our discussion, Congressman Edwards. As we discussed, and as I've discussed going back to my confirmation hearing, rural healthcare in particular is super important to me. I grew up rural and saw a company come in and buy up a lot of physician practices, and so I've seen the effects of it. The commission has a pretty remarkable track record of policing hospital mergers. We don't get them all right, but it's one of the things the commission is better at than almost anybody, anything else that it does. I know you've asked for a briefing on the HCA merger, and I think we've set it up with you. In terms of what we can do, so the commission's first antitrust enforcement action since I became chair was in the healthcare industry. It was to block a merger of 2 medical device manufacturers that we allege would have increased prices. We have ongoing litigation involving PBMs. We have the PBM report. I think continuing to make sure, we've also advocated against certificates of public advantage in states that allow
So
hospitals.
in your interest of time, respectfully, he's only going to give me 5 minutes. What can you do going forward to ensure that rural health care in America is protected?
We will continue to police hospital mergers as effectively as we've done for the last 2 decades.
How can you use your role as a federal regulator now to review the HCA and Mission Healthcare merger and take the necessary actions to reverse it if you determine that it's inhibited competition within the healthcare industry in Western North Carolina?
The commission doesn't approve mergers. If the commission declines to bring an enforcement action, it isn't an approval. So the commission always continues to monitor competitive effects in markets even after there are mergers that are not blocked. I'm happy to work with you and your staff, and my staff are as well, to understand the effects that the mergers had on rural North Carolina.
Thank you, I appreciate that. And in the interest of time, I'm going to accept that offer and let's work together. Now I'd like to ask, I'm informed that you may intend to file an amicus brief in a Texas Attorney General's case that would, if successful, cause asset managers to divest from the coal industry. Can you speak to that real quick? Is that true?
So The state of Texas, along with a coalition of Republican attorneys general, brought a lawsuit against asset managers and accused them of having driven up the price of energy by driving down output in coal and oil, which, if true, is sort of a shocking, horrible thing that has been inflicted on all of us by driving up our energy prices. We have monitored, us in the Department of Justice have monitored this case closely. I think this was an important and groundbreaking case brought by Attorney General Paxton, and if true, could potentially, remedy increasing energy prices by making sure that asset managers can't collude to drive down output and increase prices.
And so, real quick, because I'm running out of time, how does that support President Trump's energy policy?
President Trump has made it one of his chief priorities to unleash American energy so that prices for energy go down, which it promotes growth, makes it easier for all of us to put gas in our cars. The accusation in that case is that asset managers were colluding in secret to drive up our energy prices. That is exactly the sort of thing the antitrust laws are designed to protect all Americans from. And we have monitored this case very closely.
Thank you, Mr. Chair. I must yield. I'm out of time.
Thank you, Mr. Edwards. Chair now recognizes the ranking member for any questions he may have in 5 minutes.
Thank you very much, Chair. Mr. Pocan and I are playing tag team here. Chair Ferguson, I'm concerned this committee's ability to fund the department agencies in our bill, including the FTC. But I want to ask you about the staffing levels. The FTC is already down, as I understand it, 1,221 FTEs. Is that accurate?
I do believe that is our current number, yes, sir.
And there's a goal to go even lower. Is that accurate?
We are trying
In other words, you're still trying to reduce.
we are trying to get our employee levels down to a level we can actually afford given our current appropriation, yes.
And what level is that?
Because this is largely being driven by attrition rather than layoffs, it's difficult to predict exactly where it's going, but we are trying to get down around the 1,100 range.
When you say attrition, are you calling the fork in the road and voluntary retirements attrition?
Yeah, when I inherited the agency, it was very clear that we had more employees than we could possibly afford. We were using carryover funds to pay our employees. That is not sustainable. That's not responsible. But I wanted to get the agency to healthy employee levels without having to do layoffs. And so we've offered the deferred resignation program again. We've offered VERA and VSIP across the entire agency to try to get us to a healthy full-time employee level without having to do layoffs.
Now, has there been a study done on what the appropriate level, when you say healthy level, presumably, and as I said at the beginning, I don't know that I've read a more detailed opening statement. And as I said, fully noted at the bottom of almost every page. So you've done a lot of studies. But is there a study that you could provide for the committee which says what the appropriate level of funding is to meet the very numerous objectives that you outlined in your statement that you want to achieve?
I can't identify a study, but what I can say is that the levels that this committee chooses to fund us, we will maximize the American taxpayers' return on investment. We consistently send back to the Treasury and to consumers billions of dollars, either in the form of lower prices or recovered unjust enrichment from fraud. And no matter what this committee funds us at, we will keep doing that, which is just a testament to the fact that the FTC has, in my view, the best civilian staff in the federal government. So look, the appropriate healthy funding or level of employees is driven by funding decisions this committee makes. But whatever funding decisions this committee makes, we will maximize your return on investment.
Well, we made a decision. We made a decision in fiscal year '24. We reaffirmed that in fiscal year '25 in the CR. And now every one of them was offered early out and to be paid through September 30th. Every one of your employees, whom you have just said are outstanding, and you said that in your statement, which I appreciate. I represent, by the way, 77,000 federal employees. And so I appreciate that statement, which I think is accurate. Why would we send every one of those people? Because clearly, some of them must be necessary to accomplish the objectives you set forth in your statement. A notice, you can leave and get paid through September 30th.
Because we could not afford to pay all of our employees at the levels Congress had appropriated us. The previous administration hired radically more people than we could afford to pay, and we were eating into carryover funds just to cover payroll, which is a deeply irresponsible way to run an agency. My goal was to get, and remains, to get the agency to healthy employee levels in light of the money that Congress appropriated the
Let
agency.
me repeat my question. What is the healthy level?
The healthy level is what we're aiming for, which is in the 1100.
No. I know that's what you're aiming for. That's your objective. What is a healthy level?
But-
Given the very important work that you outline in your statement, what is the level that you recommend you should have? Comport with your dollars available to you and the work that you have.
So in light of the dollars available to me, the number we've been discussing around 1,100 is the healthy level because that's the affordable level. In terms of accomplishing our mission, we can accomplish the mission with 1,100 employees. I have no doubt about it because our people are really, really good. We have shifted our priority, especially away from rulemaking, which is time and resource intensive, back toward law enforcement, and are moving resources in that way. And that is the priority of this administration. It's my priority, and we have the employees to do that.
Okay, and is your request is an FTE level of 1,100 to be funded to 1,100? Is that your request?
So given the current status
I
of
know
the
we
budget,
have a skinny budget at this point in time, so that's, you may or may not be able to.
so I'm not in a position to discuss the specifics. But what I'm saying is 1,100 is healthy given the current CR funding level, and we will get the job done, period.
Okay, well, I'm a little over time. I'm not sure what you mean, given the current funding level. What I really want to know, and maybe you can do for the record, is what level do you think you need to accomplish the objectives you set forth in your statement? Thank you, Mr. Chairman.
You'll have another round, too.
Oh, good.
The Chair now recognizes the gentleman from Georgia, Mr. Bishop, for 5 minutes of his questions.
Thank you very much, Mr. Chairman. Welcome, Chairman Ferguson. I've been hearing from my constituents numerous complaints about the practices of the pharmacy benefit managers, which they say are driving up the prices of drugs, making it harder for small independent pharmacies to stay open, particularly in rural areas where pharmacies are fewer and farther between. Over the past couple of decades, the FTC has allowed vertical integrations within healthcare, leaving only a few companies that not only own PBMs, but also own pharmacies and other healthcare facilities. These big companies have become powerful, and they often threaten small independents with contract termination if they don't conform to reimbursement models and rules. So I'm very pleased that the FTC has taken action to enforce the law on it and to address the PBM excesses. Does the FTC, in your judgment, have sufficient resources, and will this budget give you sufficient resources to address what appears to be a large issue for the affordability of prescription drugs?
I agree with you, especially on the concern about PBMs in rural communities. Just a couple months ago, I went and visited a decades-old independent pharmacy in rural central Virginia, very near where I grew up, and sat with the owner for about an hour and just listened to him explain the situation in which he finds himself. And independent pharmacies are super important to small towns. If you drive down the main street of a small town, post office, a church, a restaurant or two, and the pharmacy. And independent pharmacies in particular for rural communities, that's often the gateway to healthcare. The pharmacist often participates in an individual citizen's healthcare decisions. So protecting independent pharmacies is critically important. As I discussed earlier, we have the ongoing 6B study to which I'm devoting substantial resources as well as law enforcement. We have the resources to complete the 6B study. We have the resources to carry on law enforcement. Part of that has to do with shifting resources away from rulemaking, which I don't think the FTC should generally be
But you're
focusing
also
on.
engaged in litigation.
That's
And
right.
of course, I know you can't discuss the specifics of the litigation, but are you actively pursuing that litigation to make sure that?
Absolutely, Congressman.
Okay, thank you very much on that. Let me try to reclaim my time and talk about grocers and our pharmacies. Under the helm of Chairman Khan, the FTC filed the first Robinson-Patman Act enforcement action in decades. And I've heard from independent grocers in my district that have had a hard time competing in rural environments because of the spending power of their bigger competition. In far too many cases, grocery stores have had to close because of a lack of profitability, leaving behind broad swaths of food deserts in rural America, and 50% of my district is rural. Can you give me an update on the FTC's enforcement of the Robinson-Patman Act and what future plans you have for enforcement of this federal law, and whether or not within the sphere of what you're asking for resources, you will have those?
So we have two ongoing litigation, and I can't obviously discuss the specifics of the litigation. I've written pretty extensively on the Robinson-Patman Act as a minority commissioner. I think that the decision that the government made in the 1970s to quit enforcing it was bad. It is a law. It is a law passed by Congress. The executive branch's job is to enforce the laws passed by Congress, even if there isn't full agreement on the policy underlying those laws. I do think, however, it is very important that when the FTC brings Robinson-Patman enforcement actions, that it doesn't do it in a way that could elevate the costs that consumers have to pay for goods, which is a risk when you bring Robinson-Patman enforcement cases. And so my view is that with the commission should not bring Robinson-Patman Act cases unless we know that the beneficiaries of the discrimination have market power that they can use to hurt consumers. I think that's the time that the commission should bring Robinson-Patman Act cases. So because my job is to enforce laws that this body has passed, I am open to bringing Robinson-Patman Act cases. But like I said in a previous dissent, we have to do it only in circumstances where we are very confident we will not be raising
So
prices
you're not
for consumers.
confident of that that's the case now?
Well, I think it depends on particular markets and particular market participants. I'm open to bringing these cases. I'm open to using resources, but I'm not going to bring cases unless I'm very confident that that case will not increase the prices the consumers have to pay in the marketplace.
There are some pending cases.
Yes, we've got two going right now.
Okay.
Thank you, Mr. Bishop. Chair now recognizes himself for the second round. Congress recently passed the Bipartisan Take It Down Act, which I was proud to support, requiring online platforms to remove non-consensual intimate images within 48 hours of a victim's request. The legislation tasks the FTC with ensuring the platforms comply with the law. What additional resources will be required by the Commission to enforce the Take It Down Act?
We are really excited by the Take It Down Act. This was one of President Trump's priorities. We think it's going to do a lot of good for vulnerable Americans. This is a new front of enforcement authority for the FTC. It involves dealing with some oftentimes really horrible material in order to conduct the investigation. So I think we basically need three things. The first is I'm going to need sort of a segregated technology system to house this material when we're conducting investigations. We're not going to want that intermingled with the sort of other bread and butter data that the commission brings on to conduct investigations. And second, I'm going to need to hire some specialist investigators that deal with this stuff. Dealing with this stuff takes a real psychological toll on investigators, but there are investigators and lawyers that have training dealing with this stuff as prosecutors or as civil investigators in other context, and we would want to bring some of those folks on to maximize our enforcement efforts. So those are the sort of the two buckets, three specialist investigators and specialist lawyers to help enforce these things. Those are the three buckets: segregated IT, specialist investigators, specialist lawyers. And I'd love to work with you on making sure that we will have the resources to carry out this super important priority.
As a recovering prosecutor, I understand how important it is to also maintain that as evidence.
Yes, exactly.
In those cases.
That's right.
Certainly, one of the most shocking things you saw was in, say, the middle school, junior high school setting or high school, where images get shot around and kids send them to each other, and next thing you know, you have 800 counts on 800 separate people for that type of juvenile pornography. So I think it's very important that they have the ability, you have the ability to make sure that stops immediately.
I totally agree. And because some of this material will potentially be CSAM, it is really important that it is segregated from everything else that we do and that we have specialists that know how to deal with it.
Advances in artificial intelligence have increased the ability of scammers to, unfortunately, to deceive and defraud customers. How have you seen the fraudulent schemes become more sophisticated, and what are you doing to protect consumers from them?
Yeah, so I think AI can be used particularly for certain types of schemes to sort of supercharge the fraud. AI makes it easier to impersonate someone else. It's actually, frankly, quite terrifying. I don't know if anyone on this committee has ever gotten a call of like an impersonated loved one, but I have friends that have gotten calls from like impersonated family members. It's like a truly terrifying experience. So we have the impersonation rule that we are bringing enforcement actions on to recover civil penalties for violations of this. We had a competition that we ran last year to encourage people to develop voice cloning technology that will allow law enforcers to detect when AI is being used to perform impersonations. This is going to require sort of a whole of government approach because we have to both stop it before it gets to the consumer through their phone, but we also, we have to work because a lot of this is criminal activity. You need prosecutors to assist. A lot of this comes from outside of the United States. These are people who are not going to be super responsive to sort of the civil law enforcement component of the FTC since they're already taking tremendous criminal risks outside the United States to do this. But this is one of our top priorities, particularly given that this is often aimed at some of our most vulnerable populations.
Like there are not enough schemes targeted at these elderly.
That's exactly right.
One of the things that I'm interested in as well is I know that it was used in the form of manipulating President Biden's voice to tell voters in a state not to come in the next day for the primary. In my time in Homeland, I attended a lot of cybersecurity ones, and they said that that was the start. In 28, you could produce the whole candidate, and somebody would never have to leave their house, yet there would be images of them all around. So what I also have a concern with is competition and consolidation in this industry, so you don't end up with just one sole source of this stuff. Have any thoughts on how you're going to prevent that from happening?
Yeah, I agree. I mean, the United States is the AI leader right now, and part of that is because we have a competitive, dynamic economy, and competition breeds innovation, and innovation is what gives us AI, and is what gives us our advantage over China, for example, because we are competitive and competition breeds innovation. It is very important that the FTC be particularly vigilant to make sure competition problems don't seep into AI. At the same time, the other advantage that the United States has is that we don't reflexively regulate new technologies. We let them develop, we encourage innovation, we encourage experimentation, and we see how things go, and then we address problems as they arise. I think that is equally important. Protecting competition in this space is important. Equally important is making sure that government regulators don't intervene too early, particularly with a technology that is transforming constantly, faster than even its engineers can predict. We don't want regulators coming in heavy-handed. By the time they even figure out what's going on, it will have changed. I think it's very important that that American entrepreneurial spirit be protected, both from anti-competitive consolidation and from government overregulation.
Thank you. The chair will now recognize the ranking member for additional questions.
Thank you very much. Mr. Chairman, you were appointed a year ago?
A little over,
A
yes.
little over a year ago. Do you believe that the commissioners are at-will commissioners?
I believe that Article 2 of the Constitution gives the president the authority to remove commissioners at will, yes, at the FTC in 2025.
So you believe all the commissioners at will?
I believe that the commissioners at the 2025 FTC are removable by the president, yes.
Okay, while we disagree on your conclusion, which is usual for lawyers, if in one of your dissents, Mr. Biden had sent you a note saying, we find your continued service on the FTC to be inconsistent with my administration priorities. Wouldn't that compromise the independence? Wouldn't that compromise your decision-making? Wouldn't you be thinking, is the president going to like my decision here if I'm in the minority and I can just be fired? Doesn't that compromise the independence and independent judgment of each and every one of the commissioners?
When I took the oath of office as a minority commissioner in 2024, that oath obliged me to enforce the law without fear or favor. If the President of the United States concludes that my law enforcement decision is incorrect and orders me removed, that is what democratic accountability looks like. No one voted for me. No one elected me. And they did elect the president, and they put the president in charge of the entire executive branch. And I think In a democracy, it is critically important that everyone who wields substantial power over the lives of members of that democracy is accountable back to the people. And the only way we are accountable to the people is through their elected president. So I think that that chain of accountability is critical for making democracy work.
I think that's very critical in undermining the independence and independent judgment of agencies created by the Congress to be independent. In fact, you were quoted as saying you thought the best thing to do was to reach consensus. And that's why the Congress created bipartisan bodies as opposed to 3 Republicans or 3 Democrats. Your opinion, of course, mirrors Mr. Vogt's opinion and the President's opinion, who believe that almost every employee in the federal government ought to be at-will employees, which would compromise the civil service system very substantially and create a political service, not a civil service. I want to ask you about the cases they're pending. But let me say something in your comment on China. China is now outcompeting us in a number of ways. And that is of great concern to all of us, I think, where China has become #1 in a number of different economic categories. I share the President's view. I share the view that we pursued by investing in competitive ability in the 117th Congress with a number of pieces of legislation that I mentioned in my opening statement. So I would hope that, again, on that 1,100 that you talked about, that is a number consistent, not with Mr. Musk, I'm going to cut $2 trillion, which was, of course, an absurd statement within the context of getting to an objective and keeping competitive with the rest of the world and keeping our country safe and keeping our people safe. But let me close by calling to your attention a statement that was made, totally inconsistent with the statement you made, with which I agree. The statement is, we want the bureaucrats to be traumatically affected. When they wake up in the morning, we want them not to want to go to work because they are increasingly viewed as villains. We want to put them in trauma. Do you know who said that statement?
I don't.
Russell Vogt, the director of OMB. Do you share that view?
My view is that the FTC has an important mission to do, that it has to conduct that mission consistently with the President's priorities and with the budget that this Congress has given it. And that is what I wake up every day trying to do. I know it's what my staff wakes up every day trying to do. I know it's what my colleagues, Mr. Metter or Commissioner Metter and Commissioner Holyoke wake up every day trying to do. And that's what I'm focused on.
Could I correctly interpret that as a no?
I'm focused on protecting the American consumer from monopoly and fraud. You can interpret it that way.
So yes, I can interpret it as a no.
You can interpret, I am focused on protecting Americans from
You
monopolies
don't want
and
to
fraud.
say that you disagree with Vogt. I understand.
I have not heard this statement before, so have no position on it. All I know is what I am focused on.
Okay. Well, forgetting about who it's for, you disagree with that statement?
I have no position on the statement. I am focused on the FTC's mission of protecting Americans from monopolies and fraud.
Chair now
Might
recognizes
as
the
well yield.
Chair now recognizes the gentlelady from Iowa, Mrs. Henson, for further questions.
Thank you, Mr. Chairman. And Chairman Ferguson, I want to reiterate, I appreciate the agency's focus on accountability. Again, coming back into the focus here, you mentioned in your opening statement, the 2-year hiring spree that was, quote, taking the FTC to levels that they couldn't sustain. We have to right that ship. Many agencies saw increases over the last several years of more than 30%. That is unsustainable. So I appreciate the work you're doing to right-size the agency while still executing on the priorities at FTC. You talk about the contract spending reductions, $6 million. I'm sure that's just kind of scratching the surface this, right? And in all of these hearings, I think there's one common theme. It's that we are peeling back the layers of this onion and finally getting a look at all of the waste, the duplicative nature of some of these agencies and their budgets. And we as appropriators need to do our job. So I appreciate you coming before us today to answer some of these questions. And under the previous FTC chair, obviously, we saw this hiring spree happen. We saw Chair Khan aggressively work to regulate American businesses while claiming that she was protecting competition and consumers. So again, you talk about your refocus on away from rulemaking and back on protection. Can you share with the committee some of the lessons you really learned from the previous administration and the impacts of those regulatory burdens on small businesses, farmers, working families, like those you visited in rural Virginia recently?
Yeah, my experience over the course of my whole career is that even well-intentioned regulation tends to have unanticipated effects, and those effects are normally visited on the least powerful participants in an industry, which is normally small and medium-sized businesses. Big businesses can afford to lobby regulators and lawmakers to get the outcomes that they want in a way that small and medium-sized businesses cannot. And there is always a risk with regulation that regulation will be used to insulate monopolies or to create monopolies. But it's hard to sort of predict, when well-intentioned regulation is going to do that. I think that, the benefit of the way that the antitrust laws work is that the principal motivation is don't harm consumers and workers in the marketplace. Free markets are good, they work. Don't, within the free market structure, harm consumers to gain an advantage. And our job is to make sure that isn't happening. We're not central planners. We don't do industrial policy. Our job is to let the markets work by making sure that people within them aren't cheating by harming consumers to get a leg up. And I think that that sort of flexible general approach backed by rigorous investigation and law enforcement, rather than trying to pick winners and losers through regulation, is the way that we keep America competitive, it's the way we keep her dynamic, and it's the way that we achieve growth that benefits everyone, especially workers.
You mentioned earlier in this hearing that you had a mechanism for people to kind of self-report. And one of the frequent things that I try to talk to our small businesses about is give me a list, right? Give me a list of the regulations. Everybody says I need regulatory relief. Give me a list of what's holding you back. What is that mechanism? And obviously it's designed to make sure that we can deregulate as much as possible. And then can you, again, give me kind of a scope of what the next steps that you're taking in terms of presenting that information to the administration?
Yeah, there's a place on our website that you can go. You just fill out a form, identify what you think the regulation that is anti-competitive is, give a brief explanation of why, and then it shows up in our team's inbox and they're ready to go on it. I encourage Congress to do this too. Again, you all interact with your constituents in a close, personal way. You hear from your individual small businesses about what's holding them back. I've had similar conversations where I've had people come in and say, you really need to go after anti-competitive regulations. And I'll say, I agree. Can you please give me the list? Yeah. And they'll go, oh, well, no, the list is very helpful.
Be specific, right?
Yeah, exactly, yeah. So I encourage Congress, if you all hear from your constituents, let us know what they are too. We've asked the agency heads, consistent with the president's executive order, to do the same thing. Once the request for information, which is the one the public can use on our website, and the agency responses are in, we will be going through them proposed reg by proposed reg and determining if they're anti-competitive, and if they are, either proposing shrinking them down to size so that they are protecting whatever they're supposed to protect without damaging competition, or recommending that they be deleted entirely because there's no way to save them while still promoting competition.
Is there a certain time frame that you're looking at, and I'm almost out of time, certain time frame you're looking at getting some of this feedback in so that you can, number one, work through the process, because I know it'll take some time to figure out what's actually anti-competitive versus what people just don't want to comply with, right? I mean, I think there's probably a balance to be, there's definitely a balance to be had there, but I think, is there any kind of timeline that you're looking at?
The RFI closes in a couple months, and agency responses are due to us on a rolling basis. So once we have those in, we're building the team with the Department of Justice, who has a lot of resources that will work alongside us on this, just like the president ordered. I don't know exactly when the outcome or when our product will be made available, because at this point I don't know how many regulations we're going to be asked to review, but we'll have an army of economists and lawyers ready to go to dig into these things, to find the ones that are anti-competitive, and go back to OMB and the president and say, here's the list we recommend get rid of.
I'm sure Iowa business owners have some glaring examples they'll be happy to submit, so thank you so much.
I look forward to hearing about them.
Thanking you so much,
Thank
Chairman
you.
Ferguson. I yield back.
Chair now recognizes the gentleman from Maryland for any further questions he may have for 5 minutes.
Thank you, Mr. Chairman. I did want to follow up on the ranking member's questions about the at-will issue. So I mentioned in my initial round your statement, the March 18th statement, and that it didn't contain the language with respect to inefficiency, neglect of duty, or malfeasance in office, which comes from 15 U.S.C. Section 41 of, I guess that's the Federal Trade Commission Act. But I think if I'm hearing what your answer was, the reason you didn't include it is because you think the language is superseded. In other words, that Article 2 makes it unnecessary so that the president can fire without regard to that statute.
That's right, Congressman Ivey. After the Supreme Court's decision in SELA law in 2020 that said that Humphrey's executor does not apply to agencies that wield substantial executive authority, whatever was true of the FTC in 1935 is just not true of the 2025 FTC. We're one of the most powerful agencies in the federal government. We have rulemaking authority, law enforcement authority, investigative power. After SELA law in 2020, Article 2 requires that the president be authorized to remove them at will.
Okay, and that's going to be, I guess, a central issue in the litigation that you're a defendant in.
That's right, Congressman.
All right, and would it be also your view beyond this particular, with respect to the FTC, that that's true for all independent commissions at the federal level?
The only one I have a position on, because it's the only one that I've studied myself as a defendant in the litigation and as the agency head, is the FTC. Different agencies are different. They have different historical patterns.
And there's nothing Congress could do about it, I guess, based on the statement you're making, because any statute we passed along the lines of 15 U.S.C. 41 would only be a statute, and you're saying there's a constitutional ability for the president to fire any one of these commissioners at will at any time, regardless of what Congress says.
So not quite, and I don't mean to quibble, but what the Supreme Court said in 2020 in SELA law is Congress cannot insulate from removal agency heads at agencies that, quote, wield substantial executive authority.
I got you. But given your conclusion that this agency wields that kind of authority, short of us stripping the FTC of certain levels of authority, there's nothing Congress could do to protect commissioners from at-will or even arbitrary termination.
At the FTC, yes, and I do want to be clear, my former colleagues in their brief have said that if they agree with the president's and my position on SELA law, they have asked the court to hold unconstitutional statutes that this body passed after 1935. A sort of shocking thing to say.
Fair enough. I want to go quickly to the chairman's questions with respect to the Take It Down Act and, well, your comments about that and AI fraud and impersonation issues, which are of deep concern to me. But I wanted to see if I could get you to talk about that in the context of another statement you made, which was that you want to shift from rulemaking to enforcement. And I want to make sure I understand what you mean by that, because sort of 2 points. One is with new statutes or new areas, in my view, rulemaking could be very important in trying to get ahead of the curve on these things, especially since technology evolves so quickly. You know, to the extent we're trying to legislate to address every sort of technological change, that's going to be impossible. And then the other part with respect to the rulemaking piece, I have heard from business owners that they actually they get concerned about the enforcement component, because in order for them to find out what's permissible and what's not, they have to get wrapped on the nose through a litigation process. Whereas if there's a rulemaking process that gives them guidance, even if they don't necessarily like the outcome of what the rulemaking process is, at least they don't have to litigate it. And, you know, as we know, the litigation piece can take years, potentially, in some of these circumstances. So real quick, I only have 36 seconds left. If you could walk through some of that for me. But the rulemaking piece in particular, are you moving away entirely from rulemaking or just trying to hedge it back to some extent?
When Congress directly instructs the commission to adopt a rule, like it did, for example, in the Child's Online Privacy Protection Act, the commission will adopt rules where we're expressly ordered to. A lot of the rulemaking of the last 4 years were rules on Section 5, just our general, anti-fraud, anti-unfairness statute. My position is that we protect consumers most when we take bad actors to court and win judgments, more than spending several years writing a rule, preparing it for release, and then defending that rule in court. For example, the non-compete rule has literally never gone into effect because it was enjoined after its adoption. We could have been using those resources to bring non-compete cases rather than the rule. My view is, rather than the
I'm over time, but real quick. So with respect to the Take It Down Act and the AI fraud impersonation legislation, you're on board for aggressive rulemaking with respect to those two so that they can be enforced and protect the public.
So the Take It Down Act would not require a rule. The second that it becomes effective, we can start enforcing the requirement to abide by takedown notices. That wouldn't require a rule, and we will, assuming that we have the resources available, that will be one of my top priorities. And that's what I mean by enforcement. When Congress passes a law that says to people in the marketplace, don't do X, if someone does X, I would rather spend resources taking those people to court than writing a rule about it.
Thank you.
Thank you. The chair now recognizes the gentleman from Missouri, Mr. Halford, for any questions he may have.
Thank you, Chairman Joyce, and thank you to my friend Ranking Member Hoyer for holding this important hearing today. Good to see you again. You were in our office, I think, last week, Chairman Ferguson. I'm excited that you're leading the FTC. In your opening remarks, you mentioned how the Trump-Vance FTC has gone back to the agency's roots, namely enforcement of the law, which is a good thing. While I commend you for your realization that the power to write laws is and should remain right here in Congress, there are still actions that the previous chairman or chairwoman took to go beyond the agency's authority. I have serious concerns about the so-called independent agencies usurping lawmaking authority from Congress. Chair Ferguson, can you comment on the CARS rule, please?
The CARS rule was adopted, it was vacated, and the period to seek cert has long since run. So it is not effective, and at least as of the day that we're sitting here, I currently have no plans to take up the rulemaking again.
Very good. I was a proud supporter of the Take It Down Act, which passed Congress last month. In a follow-up to my friend Mr. Ivy's question with you regarding that, this act would require the FTC to enforce notice and removal requirements for non-consensual intimate visual depictions. So you talked about resources. Going forward, you are going to enforce this. You don't need a rule to do this. What resources do you have to make sure that this happens?
So what we need segregated IT systems. A lot of this material is truly disgusting stuff. Some of it will be CSAM. We don't want that intermingled with the rest of our data infrastructure. And then we'll need specialist investigators and lawyers who can deal with this often truly horrifying material.
How much extra is that going to be an investment from the taxpayers?
So given the current status of the budget and the skinny budget, I'm not in a position to discuss specific numbers, although I'm happy to have my staff discuss that with you directly offline.
When you get those numbers, we would like, this is very important, I think, for the future of our country. And if it's going to be done the right way, not through rulemaking, but through enforcement from you and the Federal Trade Commission, we've got to make sure you have the resources you need to do the job to take care of this issue.
I look forward to working with you on getting those.
President Trump recently issued an executive order to reduce anti-competitive regulatory barriers. How is the FTC implementing the executive order, and has the Commission already identified specific regulations that are inhibiting market competition?
So consistent with the President's executive order, which I think is one of the most important things that the President has done in a series of amazing executive orders, we issued a request for information to the public, asking especially small business owners, if you are aware of regulations that are making it harder for you to compete, tell us what they are. We wrote letters to all of the agency heads in the federal government last week and said, send us a list of regulations that you think are anti-competitive that you enforce. And if you think that they should not be deleted, an explanation about why they should not be deleted, because presumptively we think anti-competitive regulation should be deleted. That RFI, that request for public assistance, is still open. It closes in the next couple months. The agency heads are supposed to produce stuff to us and to the Department of Justice on a rolling basis. We are waiting for stuff to come in before we start identifying specific ones. but we will have an army of lawyers and economists ready to go on this with the Department of Justice. And once we've identified them, we're sending them to the president and OMB with recommendations for deletion.
You said they're coming in on a rolling basis. You've already received some.
Not yet. They're supposed to respond on a rolling basis.
Okay, gotcha. Hey, listen, I just appreciate you and your passion for our country and for the Federal Trade Commission and really setting us on a new course. This golden age of America is going to include regulation and not rulemaking. And that's why we're here, and we're here to fund you to make sure you can do that job. And Mr. Chair, I yield back. Thank you.
Thank you, Congressman.
Thank you very much, sir. The chair now recognizes the gentleman from Georgia, Mr. Bishop, for any questions he may have.
Thank you, Mr. Chairman. Chairman Ferguson, it's been reported in the news that FTC is working with DOGE to make cuts to your agency. Can you tell us what the role of DOGE is at FTC and what data have they accessed and what data have they copied? And can you assure the public that DOGE and its affiliates are not accessing confidential business data or sharing the data with potential competitors of the businesses, not limited to but including the Musk network of businesses? Congress first established the FTC as an independent agency. Tell us how this is still the case in the White House and private individuals with temporary government positions have such unprecedented access and control over the agency's operations.
I can definitely tell you that no FTC employee, including those that are detailed over from United States DOGE services, are given access to anything they don't have a need for. The two employees that originated from USDS that have been onboarded as full-time employees of the commission received the same ethics vetting, background check, and data security training that every other employee, including me, has received. Their access is governed by the exact same rules that governs the access of every other employee, including me, which is that no one gets access to any particular part of our IT infrastructure without having a demonstrated need to access it. We have rigidly enforced those rules for every employee at the FTC.
Okay, so you actually, your agency enforces those rules?
Absolutely. There is a statute forbidding the disclosure of confidential commission information. It makes it a misdemeanor to do so. We take that extremely seriously, both because Congress has said it's a misdemeanor to do so, but also because our ability to work with companies in investigations depends on them knowing we will not leak out information. We had a real leak problem in the previous administration that caused tremendous embarrassment to the commission. The commission under President Trump has taken this issue incredibly seriously for all employees, including the ones from USDS.
So your FTC people are not worried at all about intimidation from the administration or from DOGE if they fail to comply or if they question a need that is suggested that they may not believe is necessarily so?
No, we have had USDS employees that have been onboarded at the FTC have been incredibly helpful. They helped us find contracts that allowed us that we could descope or eliminate while still fulfilling our mission to the American people. We have had a great working relationship with the USDS folks, and I unequivocally support the president's agenda.
Are there any
on
instances
efficiency.
where they've asked for information and been denied it?
Not to my knowledge, no.
Okay. I didn't think so.
All right, with gentlemen yield back, with that, our time is concluded. I know this has been a lot of fun for you, sir. But I'd like to thank you for being here today, Chairman Ferguson. There may be some members who are not here who would like to submit questions for the records. Please submit any question for the record to the subcommittee staff within 7 days. And with that, this subcommittee stands adjourned.